So almost 3 weeks of hearing in the Supreme Court before a 5-judge constitution bench on the Maharashtra crisis matter, which primarily was a dispute between Eknath Shinde and Uddhav Thackeray, finally reached an end. And the Supreme Court has reserved its verdict on the issue. Now, in the last 3 weeks, what we have seen is a lot of heated arguments between both the sides, one representative Uddhav Thackeray and the other representing the Maharashtra Chief Minister Eknath Shinde. How the issue arose was that it all started in June 2022, which resulted in some MLAs of the Eknath Shinde camp breaking away from the Uddhav Thackeray camp and joining hands with the Bharatiya Janata Party, which actually resulted in toppling of the Uddhav Thackeray government in Maharashtra. Now it's been almost 9 months since Eknath Shinde has been the Chief Minister of Maharashtra, but here in the Supreme Court there have been a bunch of petitions which challenges the decision to install Eknath Shinde as the Chief Minister of Maharashtra. Now it all started with the MLAs representing or on the faction of Eknath Shinde approaching the Supreme Court, asking the Supreme Court to step in when the Speaker of the Maharashtra Legislative Assembly issued them notice or disqualification notices, and when they reached the Supreme Court, asking the Supreme Court to step in, saying that they should be stopped because if there is a floor test held, then they will be stopped by the Speaker from taking part in the floor test. But subsequent events suggested that Uddhav Thackeray was taken for a ride by these MLAs who sided with Eknath Shinde. They joined hands with the Bharatiya Janata Party, and ultimately the governor of Maharashtra played a very crucial role when he ordered a floor test. Now what has happened in these petitions which are before the Supreme Court is actually the Uddhav Thackeray faction has reached the Supreme Court and has argued before the Supreme Court that the decision of the Maharashtra governor to call the floor test on the crucial 29th June 2022 should be set aside because it was an illegal order. Today what we witnessed was the concluding remarks by Senior Advocate Kapil Sibal and Senior Advocate Abhishek Manu Singhvi, who were primarily representing the Uddhav Thackeray faction, and they argued that the decision of the Maharashtra government to call for a floor test was not based on any objective facts before him, and in fact that is a decision that needs to be set aside by the Supreme Court of India. And moreover, besides that, there are certain issues, legal issues which have to be settled, which have been decided in the past and which need to be revisited, and that particular issue pertains whether if a Speaker of the Assembly is facing a no confidence motion, can he or she actually disqualify or send disqualification notices to the members of the Legislative Assembly. Now these are two seminal issues and unprecedented in nature that has been brought before the Supreme Court in this litigation. So when the Supreme Court passes its judgment in this case, it will actually pave the way for the democracy from here on, or as to how the governments are formed or governments are toppled in future. In fact, in his concluding remarks before the Supreme Court today, Senior Advocate Kapil Sibal told the Supreme Court that the whole country is watching the Supreme Court. This is a very crucial moment or a crucial time in the democracy of the country, and if the governors are given a free hand to call for a floor test in whatever manner they wish, then it will have a very bad impact on the status of democracy in this country. So now let's listen in to what Mr. Kapil Sibal and Abhishek Manu Singhvi argued in the Supreme Court today.
Yes, governor's decision. The respondents contend that it is the duty of the governor to hold a floor test. The only constitutionally ordained forum is the Assembly, and further contend that by whatever process or means the governor can gather the information that was required, which raises a credible doubt as to the majority of a government in power. In support of this contention, reliance was placed on the law laid down by this Honorable Court in Bomai and in Shivraj. That's their case. It is respectfully submitted that the respondent's contention is misconceived and is based on a misreading of the law in Bomai and Shivraj. It is settled law that the governor's decision to call for a trust vote is subject to judicial review, and the same is liable to be quashed if it is based on extraneous considerations. In Shivraj Chauhan, whilst holding that the exercise of discretion by the governor to call for a floor test is subject to judicial review, this honorable court observed that, quote, the court is entitled to determine whether in calling for the floor test, the governor did so on the basis of objective material and reasons which were relevant and germane to the exercise of power. The exercise of such power is not intended to destabilize or displace a democratically elected government, accountable to the Legislative Assembly and collectively responsible to it. The exercise of the power to call for a trust vote must be guided by the overarching consideration that the formation of the satisfaction by the governor is not based on extraneous considerations. That's the heart of the decision. It's not merely that he cannot call for a floor test, but the reasons on the basis of which he must call for a floor test must not be extraneous and irrelevant, which is what I tried to show yesterday to your lordships. Then, Malaj, the governor cannot resort to whatever process or means to gather information which casts a doubt on the confidence enjoyed by the government in the assembly. The governor's satisfaction has to be based on relevant and constitutional considerations. In the present case, the governor, in his decision on 28th of June, arrived at his satisfaction. The government headed by Uddhav Thackeray had lost the trust of the House on the basis that, and I quote, majority of Shiv Sena MLAs have given a clear indication on behalf of the Shiv Sena legislature party that they intend to exit from the Maha Hearing government. That's the heart of the matter, Manas. That's the decision of the governor, that 34 of them have come to me, and I recognize them. If that's germane to his decision-making, constitutionally germane to his decision-making process, he's right. And that's why I said to your lordships yesterday, and I gave your lordships the Sarkariya Commission, Maharaj, that the governor can only deal with alliances. He can only deal with parties. He cannot deal with individuals. Otherwise, there'll be havoc. Any three people from any party will go to say that now you must call for a floor test. Firstly, it is respectfully submitted that the resolution of 34 members of Shiv Sena, which is relied on by the governor in his decision on 28/6, does not state that the 34 members intend to exit from the Maha Hearing government. Moreover, only 8 out of 32 members were ministers of the government. The rest were not ministers. So how could he say, Maharaj, they want to move out of government? Only 8 of them. Thus, the governor has misread the resolution of 34 Shiv Sena MLAs as demonstrating their intention to exit from the Maha Hearing government, and consequently his satisfaction about the lack of confidence enjoyed by the government is based on extraneous and irrelevant considerations. Secondly, para 7 of the governor's decision makes it clear that the governor based his satisfaction on a claim made by a majority of Shiv Sena MLAs against the government formed by his own political party, their own political party. So on what constitutional basis can the governor recognize, whether minority or majority, a faction in the legislative party to direct a floor test? It is respectfully submitted that the governor has no power to recognize a majority faction of a legislature party, and on that basis come to a prima facie conclusion that the government has lost the confidence of the House. By doing so, the governor enters the political thicket outside the domain of his constitutional duties and facilitates the toppling of an elected government, which is impermissible in law. Paragraph 3 of the 10th schedule, as it stood prior to its deletion, stipulated that where a member makes a claim that he and any other members of his legislative party constitute a group representing a faction which has arisen as a result of a split in his original political party, and such group consists of not less than 1/3 of the members of such legislature party, the same would constitute a valid defense in a disqualification petition filed against such members under paragraph 2 of the 10th schedule. Well, my lord asked me this, a question related to this. Well, paragraph 3 said not less than 1/3. It could be 75%. So it envisaged a situation where the majority would go away, a minimum being 1/3, and give that protection. After it was deleted, neither 1/3 nor 75 will get protection. That's the consequence. And Milord, if your lordship reads paragraph 3 with me for a minute, well, it's very interesting. Original paragraph 3. Statute compilation, PDF page 50. Where is that? Statute compilation. Yeah, yes, I got it, yes. Yes, now kindly see paragraph 3 as it was. Your Lordship has, it's at page 48, PDF 50. My lords have it?
Yes.
Where a member of a house makes a claim that he and any other members of his legislature party constitute the group representing a faction which has arisen as a result of a split in the original political party. Any such group consists of not less than 1/3 of the members of such legislative party. He shall not be disqualified under subparagraph 1 on the ground that he has voluntarily given up or that he has voted or abstained from voting. From the time of such split, such faction shall be deemed to be the political party to which he belongs for the purposes of subparagraph 1 of para 2 and to be his original political party for the purpose of this paragraph. So what's one thing is quite clear, that the paragraph 3 dealt with factions. An argument to say that I am the party is contrary to the constitutional framework. Because he is not the party. Because the party is registered, Malad, under section 29A of the Representation of Peoples Act. The office bearers of the party are communicated to the Election Commission. And Malad, the Constitution as accepted is the final document. He can't now say, I am the party, because the party with the Election Commission and the party with the Speaker is only the members of the legislature belonging to that political party. So you can't say, I am the party. So that proposition is unfounded in constitutional law. So I'll read, I go back, Malad, to my submissions. So, Malad, I go back to my page 5. Thus, paragraph 3 as it stood, I'm sorry, you also have that?
Yes.
Yes.
Thus, paragraph 3 as it stood recognized a faction of the legislature party arising as a result of a split in the political party. And Malad, your lordships have now read all the documents. Till July the 4th, is there any reference to any split? No reference. No mention of split. With the deletion of paragraph 3 of the 10th schedule by the Constitution 91st Amendment, there is no constitutional recognition of a faction or group in the legislature party. Reference is invited to petitioners' written submissions 160 to 163. Malad, your lordship have it. I've given the page so that it's easy, Malad. The effect of deletion of paragraph 3 from the 10th schedule is that the Constitution does not recognize any faction, whether it consists of majority or a minority of the members of the legislature party. Why? Malad, there's a constitutional basis for that also. I tell you just why. Malad, when I seek election directly from the electorate, I don't seek election in my personal capacity. I seek election on the symbol of the party. In my activity in the House and outside the House, I continue to be a member of that party and must honor the discipline that's imposed on me. So in the relationship between the legislature and the political party has primacy. The legislature party has not primacy. So when you are interpreting the Constitution, you have to give primacy to that political party whose representative I am in the legislature. You can't in the process give primacy to the legislature over the political party, which the other side is trying to do, by saying, I am the party. It can be one member of legislature, but can he say, I am the party? So within the constitutional framework, the will of the legislators, in fact, is subject to the functioning of the political party, both inside and outside the House. Now, he can have dissent outside the House, but no dissent within the House, which is why the whip. Because there he represents. That's why Holohon says you can't go against it. That's the rationale for it, Malats, constitutional rationale for it. Then, Malats, a fortiori, therefore, the concept of a faction asserting itself in the legislative party and acting dehors the political party or calling itself the political party is not contemplated by the law, and any such claim will be per se foul of paragraph 2 of the 10th schedule. Parliamentary democracy only recognizes alliances between political parties and not an alliance between a political party and a faction of a legislature party. That be constitutional harakiri. The relevant rule in the conduct of election rules pertaining to section 33 is rule 4, that deals with nomination papers and prescribes that each nomination paper must be completed as per the appropriate form. The appropriate form for the purposes of election to the assembly is form 2B. Part 1 of form 2B applies to candidates set up by the recognized political party. Further, as per paragraph 13B of the symbols order, a candidate is deemed to be set up by a political party only if the political party provides a notice in form B to the returning officer which contains the endorsement of the political party as to the approved candidate on its behalf. Hence, from the very initiation of the election process, the identity of a candidate for an election is as a representative of the political party by which it was set up. So the primacy is of the party. The legislature has no identity other than being a representative of the party. After the election, section 66, 67 of the Act require the returning officer, once the counting of votes have been completed, to declare the election result and to communicate the same to the Election Commission and the Secretary of the House. That's very important, Malas. Kindly see that, 67 of the...
That's okay. I think, you've paraphrased it, and there is no reason to doubt it.
Right. The reason is, what he sends is that he has been elected as... C itself says, Malas, declaration of the... is sponsored by the political party and he has been duly elected. And the certificate also says the same thing. Would you go back to it, Mulaj? Then, Mulaj, item 9, corresponding rules of the conduct of election rules are Rule 64, 66, which prescribes 21C, Form 22 to be referred to by the returning officer. 21C deals with the format of declaration of the result of elections by the returning officer, and it explicitly requires the name of the recognized registered political party that has sponsored the candidate to be recorded. The same details are also required to be recorded in Form 22, which concerns the certificate election provided. Therefore, it is respectfully submitted that an elected member of the Legislative Assembly does not have any independent identity in the House except as a member of the political party to which he belongs. Accordingly, the governor could not have recognized any members of the legislature party, dehorsed their political party, and permitted them to make a representation against the government formed by the political party to which they belonged. So, Mulaj, he should have assumed that they continued to be in the Shiv Sena, and that Shiv Sena had 52 members, and all the three parties together have 152 out of a house of 280. There was no occasion for him to say, have a floor test. And undisputedly, in the present case, the group of the Shiv Sena legislature party, represented by Eknath Shinde, is a faction of the legislature party, albeit a majority. The recognition of a majority of Shiv Sena MLAs by the governor to entertain a doubt about the confidence enjoyed by the government is in the teeth of the provisions of the 10th schedule and of the constitutional scheme related to election of members to the Legislative Assembly. Therefore, governor could not have asked the government headed by Uddhav Thackeray to seek a trust vote on the floor of the House on the 30th of June. On this basis, the governor's decision rather placed a premium on the unconstitutional acts of a faction in the legislature party, allowing them to topple an elected government. He knows, because he is not a member of the assembly, but he is part of the legislature. So he knows. So he went outside the scheme of the 10th schedule as well as the scheme of the constitution to recognize a faction. Majority or minority doesn't matter. The governor is knowing fully well that a faction of the legislature party cannot be recognized under the Constitution.
Sorry, just to pause here. According to you, suppose there is a split, which is now, of course, not recognized.
Yes.
So, what would have been a split under the unamended provisions of of the 10th schedule? But there is a group of legislators who would otherwise, who have otherwise left the. They say we have withdrawn support.
Correct.
Right, whether they withdrew support here or not, that you already made your point. Now, they will incur a disqualification because there is no split which is recognized by the 10th schedule now.
Yes.
Can the governor not then look at the numbers and say that, assuming that these people say that we have left, whether they incur a disqualification will be decided by the speaker, but this conduct of these people in doing something which is contrary to the 10th schedule also affects is liable to affect the strength of the House and the strength of the number of parties in that House, or the strength of the party in that House. Can he not do that?
No.
Because your argument is he can't do that at all.
No, forget the majority. This can happen where 2 or 3 or 4 members of each political party can do the same. What you're doing is, when there was no 10th schedule, what used to happen? The same thing. What my Lord is putting to me used to happen when the 10th schedule was not there.
Right.
So you are going back to a state where the 10th schedule is not there. That's my answer. Because that's exactly what your lordships are putting to me. Can't the governor, looking at the fact that these people now say they want to withdraw support, they may be disqualified as a separate issue.
Then your submission would be that the governor can't call for a trust vote in oblivious to the provisions of the 10th schedule.
No, forget the 10th schedule. He can't call for a trust vote, Maharaj, by recognizing a faction in a political party which has no identity, which has no constitutional identity. That's my submission. Maharaj, your lordships are now looking at them as a group. They are not a group, they are individuals. There is no concept of a group within the legislature. Each is an individual. And government formation is based only on alliances. And therefore, Maharaj, calling a trust vote has to be based also on alliances, if it's been reduced to a minority. That's accepted now by Rameshwar Prasad Maharaj. They could have followed the Madhya Pradesh model, resigned. No, but they wanted to be chief ministers and posts, so naturally, they could have followed the other model. That also is a constitutional issue which one day your lordships will decide. That's also another issue. The collective decision to resign as a group, is something which is very suspect in constitutional law. Suddenly, all of them together one day decide we all must resign.
This is in line with Kyoto, unless we question Kyoto.
I have always questioned it. I have always questioned it, but that's another issue,
But it also has a bearing on coalition governments,
yes,
particularly regional parties.
Yes.
Regional parties, this argument could sometimes be very dangerous also, because there is absolutely no freedom in the party, except for one leader. Many a times it's a family which runs it, and there is no scope of anybody else coming into the fray
in fact,
and setting up an alternative, because it's impossible. Virtually, we are interpreting the constitution to say that it is just not possible for any legislators.
in fact, this has been my grievance. What happens, in the United States and then the UK, a president of the Republican Party will reach out to Democrats to get a bill passed. The insurance, actually, Barack Obama had to reach out to the Republicans for his insurance bill. And in the UK, the same thing, the Conservative Party or the Labour Party reaches out to the opposition members. There is no such thing as defection. This is the problem. But anyway, we are in another era. Yeah. At the moment, we are on the law as it stands today. So we go back to the Gairam regime, where there is no 10th schedule, and you can actually move the governor for toppling any government you want at any time you want. Yeah, a few people. There is an NCP case where only four people of the NCP actually went away. There were only 4 members. All of them went away. So it can happen.
So according to, going back to the Sarkaria Commission report, which was relied upon in Rameshwar Prasad, this was a post-electoral coalition of parties.
That's correct.
Of course, with the support of some independents as well.
Yes.
So according to it is only if any one member of the alliance and
shifts,
or one member of the coalition shifts.
That's right.
That the governor can then say that, look, as a result of one party in the coalition, one member of the coalition having shifted,
correct,
or ceased to back the government. Therefore, I feel now your vote in your confidence in the House, the confidence of the House in your government is now liable to be affected. Therefore, I call for a trust vote.
Therefore, he is not concerned with the 10th schedule at all, Malaj. Right. With the greatest respect. Right. Governor is not concerned with it. That's a separate proceeding. Whether they'll be disqualified, they may not be disqualified. If they vote against the whip, within 15 days, I can condone it. Or if you have sent notices to 16, the others may say, now I don't want to lose my membership. They will come back. That arithmetic and that, the consequences are not relevant as far as the governor is concerned, or even the court is concerned. Court is to judge the act of the governor on the 28th of June, whether that was right or it was wrong. And I might say this to your lordships, when we enter this courtroom, we are in a different aura. We come with hope, with the expectation that you are the only hope in this country. Power, if you look at the history of civilization, all injustices are based on power. Whether it was the execution of Socrates, why was he executed? He was executed because he didn't believe in the Athenian gods. He was executed. The same thing is happening today. Not in that sense. Where do we go? Therefore, this court's history has been so phenomenal, and your footprint is the largest around the world. You are the beacon, the hope of 1.4 billion people. And you can't let democracy be destabilized in this callous, uncouth fashion. I'm sorry, Mullah.
But then taking your argument to its logical conclusion, that means that the governor cannot really have regard to any individual movement of a group or a number of MLAs or MPs.
That's Bomai, Mullah. Yes, exactly. Para 88 of Bomai says that.
Lies within the province of the Speaker under the 10th schedule.
Internal dispute he can't deal with. Para 88 of Bomai, Mullah. Intra-party disputes he can't deal with. It's in my note. I succumb to it.
All right, let's go back to
yes, Mullah. Sorry. So, Mullah's decision of the governor is accordingly liable to be struck down. It is respectfully submitted that the respondent's reliance on the decision of Bomai to contend that the governor is duty-bound to order a floor test without regard to the pendency of disqualification petitions is totally misplaced. The respondents particularly relied on 119 and 121 for Justice Sawant's opinion and paras 391 and 395 of Justice Jeevan Reddy's opinion, dealing with court's decision on the situation in Karnataka. Now, 30 is important. As regards the situation in the Karnataka Assembly, the issue before the court was whether the governor, on receiving letters from certain legislators that they were withdrawing support from the government, was justified in himself coming to the conclusion that the government had lost majority and giving a report under 356 for issuance of a presidential proclamation. It is pertinent to note that the Chief Minister in that case had offered to test the government's majority on the floor of the House. Chief Minister himself, I'll test it. These are the facts of Bomai, Karnataka, which they relied upon. In that context, it was held by this honorable court that in cases where the support to the ministry is claimed to have been withdrawn by some legislators, the proper cause for testing the strength of the ministry is holding the test on the floor of the House. Because the Chief Minister said, I am ready to hold that test. And para 3 was there on that day of the 10th schedule. And what did the governor do? 356. It's in that context that Bomai says, which is why I said the other day, these decisions are contextual. There's no general principle that can be applied across the board. They can't be. Freedom of speech is a general principle. How you will actually, recognize it is the context. So, in this connection, it is necessary, I'm quoting, I'm sorry. In this connection, it is necessary to stress that in all cases where the support to the ministry is claimed to have been withdrawn by some legislatures, the proper course for testing the strength of the ministry is holding the test on the floor of the House. That alone is the constitutionally ordained forum for seeking openly and objectively the claims and counterclaims in that behalf. The assessment of the strength of the ministry is not a matter of private opinion of any individual, be he the governor or the president. It is capable of being demonstrated and ascertained publicly in the House. So first you must reach a bona fide, constitutionally valid conclusion that this requires a floor test and on relevant considerations. If you are able to justify that to the court, then the only remedy is a floor test. Well, the next paragraph, I just read the highlighted portion, para 391 at the bottom. Whether the Council of Ministers has lost the confidence of the House is not a matter to be determined by the governor or for that matter anywhere else except the floor of the House, correct? Principle of democracy underlying our Constitution necessarily means that any such question should be decided on the floor of the House. The House is the place where the democracy is in action. It is not for the governor to determine the said question on his own or his own verification, which is what exactly he did by recognizing a faction. Now, let's kindly come to para 32. Thus, S.R. Bomai is not an authority for the proposition that the governor must order a floor test whenever a claim is made that the elected government has lost the confidence of the House, irrespective of whether such claim is based on unconstitutional or extraneous considerations. Rather, S.R. Bomai, it was categorically held that the power under 356 cannot be used to... I just waste, we have a short time. My colleague has to also. I don't want to hog everything. Rather, in S.R. Bommai, it was categorically held that the power in 356 cannot be used to sort out internal differences in or intra-party problems of the ruling party. Para 82. If your lordships will just allow me to show that, if it's convenient. Well, I'll show that here. Volume 2.
There's Bommai?
Yes.
We'll read Bommai here. You have extracted it.
Yeah, I've extracted it.
Yeah, we'll read it from your extract. Much easier. We've got Bommai, of course.
Yes, I purposely did it, Mala, so that otherwise you'll have
we don't have to go back and forth at all.
You extracted it also.
Yes, I've extracted it. It's okay. Well, it's actually, I must give credit to my colleagues.
Yes.
Well, it's Mr. Tiwari, Mr. Devdutt, how wonderfully they have prepared this case. It's extraordinary. And I owe gratitude, sense of gratitude to them. Sort out internal differences or inter-party problems of the ruling party, and that exercise of this power for a purpose extraneous or irrelevant to the one for which it has been conferred by the Constitution would be vitiated by legal mala fides. You're now looking at an intra-party dispute. They have come to you, they are 34, I recognize you, I recognize the leader because he is the leader. So the governor is recognized. And this intra-party quotation is from Sarkari Amalat. It is adopted by Bommai. And it is consistent with those propositions, Maharaj, that I read to your lordships of Sarkari Amalat adopted by Rameshwar Prasad. So you can't enter into an moment you say, okay, I'll recognize these 3 people, I will entertain these 2 people, and then now you have lost majority, now you have a floor test. Impermissible. That's the old non-10th schedule regime, the Ayagram, Gayaram regime.